MSW Media.
Spy Talk, a podcast at the intersection of intelligence, foreign policy, national security, and military operations.
Welcome to Spy Talk. I'm Jeff Stein.
I'm Michael Isikoff.
And I'm Karen Greenberg.
Well, lots going on in our corner of the world, as always. We're facing a government shutdown, and as we do, we've just learned that Pete Hegseth has summoned generals from all over the world to an emergency meeting in Arlington. This kind of reminds me of Saddam Hussein. He used to pull his commanders together and say, who's going to stand up and admit they're guilty? And people did, walked into a courtyard where they were shot in the back of the head. So
You're not suggesting that our Secretary of Defense is going to do something similar, are you? Right.
Well, he said he wants to clean out 20% of the generals. Too many generals, he said.
Right.
And he's not the first one to say that, by the way. It's not some radical pronouncement. There's been an overload of 4 stars and 3 stars around the Pentagon, and as many people have noted for years. But anyway, as that goes on, and I suppose a really nicely targeted Chinese or North Korean or Russian missile could take out all those generals. I don't want to say they're going to do that either.
Hey.
Or there's any threat of them. But meanwhile, we have Trump spinning on a dime, not turning on a dime, but spinning on a dime when it comes to Russia and Ukraine, saying, well, Ukraine could probably take back all its territories. Nobody thinks that, by the way. And my own soundings over the last 36 hours or so, all the intelligence people I'm talking to say, no, not going to happen. There has to be a deal of some sort, and Ukraine's going to have to give up some of its territories. So we don't really know. Nobody can really figure out what's on Trump's mind when it comes to Ukraine today. Might find out tomorrow he's changed it again. Anyway, what are you thinking about, Mike?
Well, look, we have talked a lot on this podcast about the weaponization of the intelligence community, the weaponization of law enforcement, and it now appears it's all coming to a head this week as we speak. We're taping this on Thursday, September 25th. There are reports that the newly installed U.S. attorney in Alexandria is going to press for an indictment of former FBI Director James Comey because the statute of limitations on lying to Congress, which is apparently the charge they're going to bring against him, expires next week. We'll see, but there's been reporting in the last 24 hours that is unlike anything I've ever seen on a major case, and that is the line prosecutors in that office, assistant U.S. attorneys, wrote a memo to this new U.S. attorney, a former Trump personal lawyer, Lindsay Halligan, telling her there is no case, that there's not sufficient evidence to even bring an indictment. The standard there is probable cause, much less the Justice Department prosecution manual, which says you only bring a case when you are confident you can convict beyond a reasonable doubt. If there's not even probable cause, how the hell can they get to beyond a reasonable doubt?
I suppose that raises the possibility of a runaway jury that refuses to indict, like happened in D.C., but juries in Virginia are generally more conservative, but they
need 16 votes.
This prosecution is so over the top.
Yeah,
the jury may refuse to indict. Karen, what's on your mind?
What's on my mind is that earlier this week, President Trump issued an executive order declaring Antifa a terrorist group, or in the words of the executive order, a militarist anarchist enterprise that explicitly calls for the overthrow of the U.S. government, etc. And this is an extremely disturbing and transformative reality. For years, under presidents from both parties, there has been an attempt to pass a domestic terrorism act. There is no federal statute criminalizing domestic terrorism. So rather than go through Congress, which was unable to pass it, I think in 2022, the House passed a version of it, but it was turned down by the Senate. throwing caution to the wind in terms of the debate in Congress and the issues here, Trump just declared in an executive order that this is now a terrorist organization or a domestic extremist organization. And this is hugely problematic. You talk about weaponizing the Department of Justice. What about weaponizing the White House? And Antifa, if Chris Wray is on record, others are on record, it's not exactly an organization. Therefore,
yeah, I was going to say they might be terrorists, but they're not a group. There's no leader.
It's like indicting feminism.
But that's exactly
There's
right.
no central committee.
All of the things that civil libertarians and others were worried about with the Domestic Terrorism Act, which had to do with how do you define a terrorist, and depending on who's in power, do you define your enemies as, or those you disagree with, those groups you disagree with, as people who have terrorist aims and put them in this undefined category? And now we just have this decree from the White House. And who knows where this will go, but what this will mean or what kind of activity. It's very broad.
Yeah.
What's been outlined here could be criminalized. And so I find this extremely upsetting and not sure where it's going to go or how there can be pushback against it.
There's so many rails that this has to cross for it to actually go into effect. And there have to be compliant prosecutors and compliant judges issuing warrants, compliant FBI agents or whoever they want to rustle up to go make arrests. I mean, and compliant grand juries. I don't see much of a future for this. I think this is more performative bullshit. But it exacts a toll on people, as all these prosecutions of the revenge prosecutions do. They have little chance of succeeding, but they turn the target's lives upside down and their families. So it's really dangerous stuff. So anyway, we're going to take a kind of a spin back into the past but in an exciting new book. It doesn't sound exciting, but it is exciting. It's called America's Trial, Torture and the 9/11 Case on Guantanamo Bay, and its author, John Ryan, is our guest today. And it's just an extraordinary story. As I say to him, I'd forgotten some of the things that had happened in the torture cases in Guantanamo. And they appear as fresh and new and deeply disturbing when I revisited them in the book. Anyway, without going any further about that, I just welcome aboard John Ryan. John Ryan, welcome to Spy Talk. I must say, I didn't expect your book to read like a crime thriller, but it does. And I was totally encaptured. Your combination of your own adventures in Guantanamo Bay and with the maneuvers of the defense and the prosecution in the cases of the 9/11 hijackers, I just found enthralling. And some things I also had forgotten or was only dimly aware of just jumped off the page and shocked me. And before I turn it over to Mike and Karen, I just want to cite one. The defense teams discovered that the smoke detectors in the attorney-client meeting rooms at the detention facility were listening devices. And they also learned that the audio system at the defense tables in court could allow for eavesdropping. And that's just one of the bizarre things that were going on in these cases.
Yeah, well, thanks for having me on the podcast. I really appreciate it. And for the compliments on the book. I think I owe a lot to my editors at Skyhorse for getting me to sort of do it first person, because they said, well, the case is so complicated. If you do it kind of standard third person journalistic narrative, you're going to lose some people. If the reader goes with you on these trips, they'll experience it the way that you did. And that's going to make it a little bit more of a draw in for people. And I think that probably proved to be right. But yeah, that incident, the smoke detectors, I think, and a few other early developments in the case like that kind of set the stage or set the tone for what the case would be like, which is the defense teams, among other concerns, not really trusting the government in terms of the handling of information and the privileged nature of their communications with the defendants. It's been an ongoing source of tension, and I think kind of just set that tone of mistrust between the two sides in the courtroom.
Yeah, you sure did. And also, one of the interpreters in the case had been a CIA interpreter. I mean, it goes on and on. Karen?
Yeah, I was thinking that maybe we should just start with the parameters of Guantanamo and then get into the case itself. Because, what we've seen since, and I thought you could just run us through how many detainees are there now, as opposed to when when it had the most detainees, and then we'll talk a little bit and move into your case. Do you want to go through that?
Sure. Yeah, well, so I came into Guantanamo in kind of a later phase, and I think there were 200 or so when I started attending, and a total of about 780 people, mostly men, some boys, have passed through the detention facility. So it was a much bigger detention operation prior to my arrival, and now it's down to 15. So it's really shrunk considerably, and it raises this question of kind of, is Gitmo still open? I think a lot of us would say yes, but it's clearly different than it was when it had several hundred people at one time, and a lot of kind of management challenges of that population. It's just in a different phase now, and in some ways it makes the closure of it a little bit more complicated, because what do you do with these people at the end who probably they're most concerned about? Of course, most people who pass through Guantanamo did not have the type of information where they would even be, charged with anything. So what do you do with this population? Not all of them, but most of them left. They have some concern over.
Okay, one follow-up question. Of the 15 that remain, 9 are in the military commissions, which includes the trial that you've been following for these 10 years. 3 of them have been cleared for release and are waiting for the kinds of arrangements that can let them go in a way that will satisfy security concerns. But what about the other 3?
Well, they're in a different category, what I think has been referred to as the forever prisoner, which is that the government doesn't want to release them, but they don't have evidence to charge them. And so that's kind of the...
Is that again, what? Is it that they don't have evidence to charge them? Or do you think there are other reasons that they're keeping them there that have to do with what your book is essentially about, like Zubaydah? Do you really think the reason
Correct.
is... Yeah,
correct.
okay.
I mean, I think there's a concern with Zubaydah in particular, Abu Zubaydah, really, who is sort of the guinea pig of the CIA's interrogation techniques. Let's say he wasn't a security concern. Would you want to release someone who has that type of information about what was done to him?
Could you just remind the listeners who Abu Zubaydah is?
Sure. He was captured in, I think, March of 2002 in a firefight, and he was badly injured, but he was considered kind of an early high-level Al-Qaeda operative of tremendous interest, sort of one of the early big captures. And he was then transported to what became one of the early CIA black sites. And so he was the first detainee that we know of, at least, that for which enhanced interrogations were approved. And so they waterboarded him quite a bit.
Over and over and over and over.
Yeah. And so then they went from Zubaydah on to another suspect, and then not too long after that on to Khalid Sheikh Mohammed.
Okay.
So let's cut to the chase here. Your book is primarily about the U.S. government's efforts to prosecute the people who perpetrated the 9/11 attacks, the worst crime in American history. And here we are 24 years later, and not at all clear whether this case is ever going to trial. And there's a simple reason for that, and that's what the CIA, with the help of people in the FBI, as you bring out as well, what they did to these people. So why don't you let's go right there, because that is the crux of what this is all about, and why here we are so many years later with having no trial. So tell us what the CIA did to these people and how that has been an enormous obstacle to bringing this case to trial.
That's exactly right. So the the 5 9/11 suspects were captured in Pakistan between 2002 and 2003. They were not brought to the United States or to a court of law. They were sent to CIA black sites where they were tortured for periods of time and then also held in isolation for 3 to 4 years. And so there were really aggressive interrogation techniques, but then also profound isolation. And then after 3 to 4 years, in September 2006, they were brought to Guantanamo Bay. And the government plan at the time, and it's kind of stayed the plan, is that, well, we're not going to use what they said at the black sites. That would be inadmissible. The government doesn't call it torture, it calls it coercion. But it doesn't plan on using it. It plans on using the statements that the defendants gave to the FBI about 4 months after they came to Guantanamo Bay. So the FBI traveled with other federal agencies to Guantanamo Bay in January 2007, and they reinterrogated the defendants to get statements for a trial. The problem with that, what would maybe be called a clean team approach, the problem with that, I mean, there are many problems, but the judge eventually determined or made a decision that how they were treated beforehand would impact the admissibility of what they said to the FBI. So the defense teams would have access to some amount of evidence and witnesses from the CIA program. And that's really what they've been fighting over ever since.
It's time for a quick break. We'll be back in a moment with Scott Anderson. And we're back. Just to give a little flavor of that, because these coercive techniques, enhanced interrogation, waterboarding, and the rest were used on all high-value detainees, the 9/11 ones, as well as some of the others at Gitmo. And there's one graph when Majid Khan testified, and you write about in this book, Majid Khan was an Al-Qaeda guy accused of bombing in Indonesia, in Jakarta, the Marriott Hotel in Indonesia. And here's how this is from your book. He, Majid Khan, described his CIA torture in graphic detail: the prolonged sleep deprivation, being hung by chains and doused with cold water with a fan blowing on his naked body, being submerged in ice water while wearing a hood, and violent force feeding. On one occasion, CIA personnel sharpened the end of a feeding tube and doused it with hot sauce before inserting it into his nose. At another time, Khan said, personnel used a syringe to force feed him down his throat. Khan also said he endured numerous sexual assaults and rapes when CIA personnel rectally fed and hydrated him as punishment for his hunger strike. At one point, he said, a green garden hose was inserted into his rectum and attached to a faucet. I could feel the gush of water going into my rectum, Khan said. This testimony, which you write so graphically about, had a big impact on the judge, correct?
Yeah, I think it had a big, well, in Khan's case, the jury came back, the jury in these cases are military officers, came back and recommended clemency. But that showed in the 9/11 case the problems they would have if they've moved forward with the case, because this testimony is so, can be so persuasive, I think, in terms of the value of evidence or a future sentencing. So you're right. The Khan case, I think, was a big factor in the government deciding to move forward with plea negotiations, because the more type of detail you have in the case about this, the harder it's going to be for a jury to sentence somebody to death, even if they find them guilty.
Yeah, 7 of the 8 jurors in that case wrote that Khan's treatment, quote, in the hands of U.S. personnel should be a source of shame for the U.S. government and an affront to American values.
Yeah, and I think a lot of the Khalid Sheikh Mohammed, the accused mastermind of 9/11, hasn't testified yet, of course, in his case, but the evidence about his treatment in CIA custody is arguably worse. It's hard to kind of rate them on a scale, but clearly Khalid Sheikh Mohammed was treated about as bad as anyone, and I think that details of that treatment, as much as people may dislike Mohammed here, or even among a jury pool, it's that type of evidence for how Mohammed was treated and the others would be, quite graphic and disturbing.
I'd like to bring up something else in regard to these interrogations, John. You have produced evidence that shows that the FBI's hands were not so clean after all in these interrogations. The legend has grown up, and I think in great measure true, that the FBI objected to the torture that was going on in these interrogations, and withdrew from them. But you paint a portrait that's a lot more complicated about the FBI's role in regard to the interrogations. Tell us a little bit about that.
Yeah, a lot of that narrative is true in terms of walking away from a decision. Some of the early decisions, are we going to use these techniques on people or not? And the FBI director did not want his agents doing that. But from that point on, the FBI was, well, first of all, not to get too complicated, but the FBI was involved in the interrogation of Zubaydah sort of early on. But then after that, when the CIA program became more formalized, the FBI was for periods of time not given any access to, or didn't have direct access to, the detainees at the black sites, but they would send questions in for CIA personnel to ask the detainees. And then this information would be distributed to the intelligence community. The FBI would receive it and sort of take investigative steps or what have you with it, and then go back with other questions to the black sites for them to ask detainees, including detainees who became defendants in the 9/11 case. So, not directly there in terms of implementing techniques, but perhaps having some idea of how they were treated. We don't really know what they knew. One FBI agent said he might have had an idea that he knew that they were not being treated the way that the FBI would treat them, but he still felt that he should send questions in because he had a job to do. And there were 3,000 dead and plenty of pending threats. So the FBI was doing what it could. But there is this more of an overlap that's come out in the 9/11 case, including before going to Guantanamo Bay to conduct the so-called clean team interrogations, the FBI was able to review the cable reporting from the CIA black sites before the interrogation. So there's a little bit of overlap there. And then when they were on Guantanamo, when they typed up the notes of these interrogations that they were going to use for court, they had to type them up on CIA laptops and have the CIA review them. And so all these things sort of lead to more of a meshing between the entities than we previously knew. And we also know now, though the details are pretty hazy for the public, but a number of FBI agents were actually detailed to the black sites or detailed to the CIA program and became CIA agents for the time that they were on the program. So,
so what is the significance of all this, John, for the case? Why is that so important that the FBI was so involved, perhaps as junior partners in the CIA's interrogation program?
It's really critical for the admissibility of those statements in January 2007, that if the FBI was more involved in the coercive interrogations before conducting the so-called clean ones, then there would be a level of taint associated with what the government considered its most critical evidence. So we can never really know the extent to which an FBI agent, by going to a CIA facility to review what a defendant said when he was being tortured, and then some weeks later interrogating that defendant without using those techniques, but to try to get a clean statement. We don't know if there was a reliance on what the CIA obtained through torture, but we know there was a lot of overlap between what the CIA asked the detainees at the black sites and what the FBI asked the defendants when they were being interrogated on Guantanamo.
So the significance of this
is that it undermines this idea that what the government was getting evidence-wise on Guantanamo was separate from the torture program. The defense is saying it's been one long interrogation strategy. The CIA did it at the black sites. They conditioned them into answering questions a certain way. Then you bring them to Guantanamo. The FBI questions them. It means nothing to the defendants whether they're FBI or CIA. So they're giving the same answers to the FBI that they were conditioned to give the CIA. So there's no real separation between coercion and what the government hopes to be a clean statement. At least that is the defense argument, and it's prevailed a couple of times.
Right. And one of the other points that you make is that even if they were clean teams, just by virtue of being in a room with a law enforcement officer or with somebody who you don't know exactly who it is, who would trust that they wouldn't suffer the same kind of repeat torture that they'd had in the past in terms of answering the questions or not answering the questions, right?
Correct. And what the defense brought out with different witnesses is that the detainees were told at the black sites, generally speaking, the detainees were tortured with the so-called enhanced techniques for a relatively condensed period of time. And then they were transitioned into what the CIA called the debriefing phase, in which they just answered questions over and over and over again. And this is where the conditioning comes in. But they were told, if you become uncooperative, you can return to the hard times, right? So there was this idea of conditioning them to answer a certain way. And so when they were speaking to the FBI in Guantanamo Bay, there is this idea, well, hey, if I don't answer a certain way, what's going to happen to me? That is what I think the defense brought out effectively, because the judge, like the defense sort of in some of its later presentations, said in his ruling on this issue that, you know, the torture techniques get a lot of attention and they're important, but part of it is this period of isolation, completely cut off from the outside world, and where they're just answering questions over and over and over again. And then they're brought to Guantanamo Bay and told it's voluntary, but they're not given lawyers, they're not read Miranda rights, and they're sort of in a similar debriefing mode that they were at the black sites. So how do you really separate those two?
Exactly. And so what about the witnesses? You mentioned the witnesses before. Who would we imagine would be the witnesses to come if this ever came to trial?
So the biggest set of witnesses are the FBI agents who investigated the 9/11 case sort of immediately after 9/11 and going forward. And then a lot of those agents then became part of the clean teams that elicited the statements from the defendants on Guantanamo Bay that would be used at a trial. And the other would be some amount of CIA witnesses who would have knowledge of how the defendants were treated at the black sites prior to getting to Guantanamo Bay. So far in the pretrial phase, there's really just been two witnesses, and those are the two former CIA contract psychologists who helped design the interrogation program, Drs. James Mitchell and Bruce Jessen. So they've been the only real CIA witnesses so far. If the case goes forward, that might change.
When you say if the case goes forward, we've seen a rather dramatic episode in the case over the past year. So tell us about the plea deal, what happened with the plea deal, and where you think this is headed.
Sure. Well, and just to explain that, so there were 5 defendants at the start of the case. One is now in a different proceeding because he was found to be mentally incompetent about 2 years ago.
Ramzi bin al-Sheba.
Ramzi bin al-Sheba, and his lawyers blame his mental incompetency on his past torture. So he's out now, and they can try to prosecute him again on a different path if he's restored to competency. But for the 4 that are remaining, 3 of them, including Khalid Sheikh Mohammed, wanted to plead guilty and reach plea agreements with the Pentagon official who oversees the court. And they had worked out these plea deals with the prosecution team, over a few years, and that really would have brought the case close to a resolution. It would have queued up a really big sentencing trial, which the government hoped would be sort of its like 9/11 criminal trial would be the sentencing, probably to last 2 to 3 months or so. But then Secretary of Defense Lloyd Austin, almost immediately within a few days, withdrew from those agreements. And what's happened since is a fight over the legality of that. Can Austin withdraw from agreements after the person he appointed to oversee the court, reached in with the defendants? And eventually 2 lower courts, including the 9/11 trial judge, found that Austin could not do that. And so the plea deals had to go forward, and the defendants would get to plead guilty. But the D.C. Circuit sided with the government and said he could withdraw. So now those defendants are kind of back in the case. They were within a day of pleading guilty, or Khalid Sheikh Mohammed was within a day at one point of pleading guilty, and now he's going to have to maybe go back to.
Is either party appealing the D.C. Circuit ruling?
Yeah, so the defense teams will now appeal that.
To who?
either to the DC Circuit because they can get an en banc rehearing of the full circuit,
yeah,
or they can go to the Supreme Court. I think a best guess it would go to the DC Circuit first with that. So that's expected. It's and then, but the new 9/11 judge, because the judge who was on the case during these events has now retired, but the new judge has said that the case can go forward even while that appeal is pending. So while we don't know what's going to happen with the plea deals, he wants, at least for now, the pretrial proceedings to go forward.
Just a note about the plea deals, because I think it's sort of interesting to note, the plea deal took the death penalty off the table. We don't really know all the reasons that Secretary of Defense Lloyd Austin withdrew the plea deal, but some of it may have had to do with pressure and anger against taking the death penalty off the table. Can you just talk to us about, you referred to it before, and just talk to about a little bit better, the plan within the plea deal for what would happen in the sentencing hearing? Because the reason I ask is it's very important if we're not, in other words, we weren't going to get a trial if there's a plea deal. We may never get a trial anyway, but there was a carve out for something that would check off some of the boxes of what victims of the 9/11 attacks could expect from a trial. And can you talk about that a little bit?
Yeah, and in saying that the government prevailed in withdrawing from the plea deals is kind of a funny way to say it, because the prosecution, of course, initiated these plea talks and worked with the defense teams to come up with the agreements. And so, but we know from that prosecution team that they were planning, at least if all three defendants were going to be kept together for a sentencing trial, that it would last about 3 months. So it would be, they said something to the effect is, we want this to be a historical record of the 9/11 case. And so it was going to be a real trial, not sort of like a judge, here's a defendant, and then says, here's your sentence. It was going to be a real trial with a lot of testimony from victim family members. And there was a process by which, not everybody wanted to do this, but a process by which family members could submit questions to the defendants, which they would have to answer. So it was envisioned to be a real trial, longer than sort of any trial we have in the United States for the most part. Some are longer than 3 months, but that's pretty rare. So we were going to have a really big 9/11 trial. And I think for people who wanted this plea deal and wanted finality to the case, they think that part was maybe a little bit undersold. That there was this idea, well, there'll never be a 9/11 trial because we're pleading guilty. Well, I think for some people, this would have been the real 9/11 trial. So there's a frustration that wasn't maybe better understood at certain points.
So is there going to be a 9/11 trial?
Right now, it just seems almost impossible to imagine. But one of the things we've talked about is we don't know what the defendants are going to do. I mean, if they really do pursue their plea deals, that could, of course, go in any number of directions, including prevailing where they get to plead guilty. If not, if they're forced back into the case, which seems like it is now, if they just go through the part of the case that is remaining for them, which is litigating to suppress their confessions. One thing that's important to mention is that the fourth defendant here, who did not want to plead guilty, he wanted to pursue his kind of what you would call like the torture ruling, and he kept at that process. And the judge earlier this year, before retiring from the case, suppressed his FBI confessions because of the past CIA torture. So he prevailed on this sort of the most important part of the case, while his three co-defendants sort of exited just a little bit earlier in order to pursue plea deals. So if they have
I
to
want
come
to
back,
ask about that, John, because in one of the earlier rulings by one of the judges, there was a ruling that the FBI clean team confessions were inadmissible because they were tainted by the prior CIA torture, which seems like it was a huge victory for the defense. But where does that stand? Did that ruling hold up? And if that's the case, doesn't that present a real problem for the government?
it does, yeah. So in a separate military commission involving the bombing of the USS Cole, that defendant was also going through a suppression hearing similar to the one we've talked about here, and he prevailed. He won. The judge in that case ruled a few years ago that his past torture taints anything he said afterwards to the FBI. And that has been held up on appeal now, at least for the appellate court that is part of the commission's system. And now the 9/11 judge, for the defendant who didn't want to plead guilty, who wanted to go forward, kind of gave a similar ruling, at least ruling for the defense, that the past torture prevents the statements to the FBI from being truly voluntary.
Is that true for KSM and
No, because they exited that litigation.
So where does it stand for the three 9/11 defendants?
Yeah, so for the three, well, first off, for the one who just won that big ruling, was sort of the focus of my book,
and that's Amara Bellucci.
Amara Bellucci, who is one of KSM's nephews, the government is now appealing that ruling, so that case is on hold for the time being. But for the three, including Khalid Sheikh Mohammed, who tried to plead guilty, who still, as of now, want to plead guilty, they would have to resume their suppression cases, right? So they would have to recall certain witnesses, bring additional witnesses specific to them in order to make a complete argument. So they'd have to go back to that. It's still open, exactly.
It's still an open question.
Yeah. Right. I'm curious about what you can tell us about the current Trump administration's attitude toward these cases. As we've seen again and again, President Trump has a short fuse. He can turn on a dime like he did this week on Ukraine and Russia and so on. What do we know about his personal feelings about these cases? I suspect that he just says, well, let's just execute them all. What do you say?
Well, I think you're right about it being unpredictable. When Trump won, there was certainly, and then after this, as part of this plea deal thing was going on, people speculated that Trump could just shut down the court. Because it's a military court, it's under the Department of Defense, that he could just shut down the court and sort of maybe assess what they would all want to do with it. Because President Obama did that too when he was reelected. He halted all the military commissions. He wanted to bring the 9/11 case to Lower Manhattan, but he wanted to keep the commissions open for some other cases, and so he kind of shut down the court as he reassessed everything, and as they ended up reforming the Military Commissions Act and kind of creating a different version of the court. So
can we use some air quotes there for the reforming? Because, some would say that the Military Commission Act passed by Obama has just perpetuated what was already a legal travesty under Bush. It did not reform the military commissions. They're still stuck, and they've still been unable to bring these people to trial.
That's true. For big picture, absolutely. There are some changes in the legislation.
Made some minor changes that gave a little more deference to defendants, but the bottom line is we're stuck every bit as much as we were stuck before Obama did that in 2009. In fact, we're more stuck now.
Yeah, we might be more stuck. And I think so. We don't know all we know. I mean, Secretary of Defense Hegseth has said that, well, he agreed with Austin's decision. That's kind of all we really know. But we don't know a lot beyond that. But I do think it's unclear whether anyone's going to give this real attention within the administration. I think the plea deals, this idea of not having the death penalty, kind of blew up into a big issue. But beyond that, it's not really clear who really cares too much about it within the administration. So, but nothing would stop the administration from shutting it down and holding the defendants as belligerents, and they can hold them for until the cessation of hostilities, which of course,
which by the way is the sort of real absurdity of all this, because as has been clear for years now, they were never going to let Khalid Sheikh Mohammed go, regardless of what happened in a trial. Even if he got acquitted, he was still an enemy combatant, and he was going to be held, at Gitmo or wherever we can hold him until his final days.
Yeah.
Well, on that happy note, what a fascinating book you've written, John. I really hope a lot more people discover it and read it. It's called America's Trial, Torture and the 9/11 Case on Guantanamo Bay. It's a terrific read, very, very important.
Thanks a lot. I really appreciate it. Thanks for having me. I'm around anytime you want me back on.
Thanks.
Okay.
Oh yeah, when the trial happens, we're going to have you. You'll be our first person.
Yeah, when
absolutely.
we'll all be in our old age homes.
If we're still alive.
Right. Yeah.
Thanks again, John.
Thanks, John.
And that's it for this week's Spy Talk. Be sure to check out our complete podcast archive on Apple or wherever you get your podcasts. And if you haven't done so already, do check out the spytalk.co news site on Substack, where we offer a steady diet of scoops and original analyses on the intersection of intelligence, foreign policy, and military operations. Just Google Spy Talk and you'll quickly find your way there. This edition of the Spy Talk podcast was smoothly produced, as always, by Kanai and edited by Molly Hockey for MSW Media. And so that's it for now. I'm Jeff Stein.
I'm Michael Isikoff.
I'm Karen Greenberg.
We'll see you next time.
For more original reporting and insights like this, subscribe to spytalk.co on Substack and follow us on Twitter at @talk_spy. If you enjoyed our podcast, subscribe and leave a review on Apple Podcasts, Spotify, or wherever you get your podcasts.
MSW Media.